afternoon again, and welcome to this legal track of the SFSCon 2023. So, our first speaker that will introduce the topic of legal in free software and open source technologies is Karen Sandler from the Software Freedom Conservancy, is right. And she will introduce a little bit about the history, but also the path of copyleft and GPL, right? So we can have this introduction to the topic, and I'm looking forward to all the speakers of this afternoon. So Karen, please, the floor is yours.
Thanks so much. Hi, everybody. We've got 15 minutes to cover the past, present, and future of the GPL. Are you ready? Yeah. Super quick introduction to myself. I am an engineer turned lawyer. I am a cyborg because I have a heart condition I was born with, and I have an implanted pacemaker defibrillator in my body for which I cannot see the source code. That defibrillator shocked me unnecessarily while pregnant for no other reason than I was pregnant, basically. My heart was palpitating. It stood for the proposition that our technology may not be made for us. Only 15% of defibrillators go to people under the age of 65. All of this made me passionate about software freedom, about making sure we as a public have control of our own technology. So all of that led me to the Software Freedom Conservancy, where we do three major things. We support alternatives to proprietary software. We make sure that our software cannot be made for everyone unless it's made by everyone. So we do diversity and inclusion, and we have paid internships for folks subject to systemic bias. And we stand up and defend the GPL. Raise your hand if we're going to figure out together what we know and what we're going to do. So raise your hand if this is the first you're hearing about copyleft, in which case I'm really excited you're here. Anybody not know what copyleft is? A couple, no, where we are generally in a place where people know what copyleft is. So I'm going to skip that part, and we're going to talk about this idea of copyleft that came into fruition, where people thought that that the just licensing, or raise your hand if you have licensed code under a copyleft license under one of the GPLs. Oh my gosh, it's like a third of the room. You are all awesome. So how many people here, when you licensed code, when you contributed code under a copyleft license, thought that just by making that contribution that the license would be followed? How many people here? One person here. Two people here. So we are all really cynical people. So the past of enforcement of the GPL involved this idea of thinking, if we license our code under a copyleft license, everyone else has to follow those rules. And everyone will stick to those rules because we ask them to. But what we know now is that that simply doesn't happen. So the early days of GPL enforcement were the likes of Harold Velte. Raise your hand if you've heard of Harold. Amazing work. I'd say like maybe a quarter of the room. Harold is a developer who went and asked companies to follow the rules and to produce their source code. And when he did that, it was very early days, and so there was a great opportunity for education to explain to companies who hadn't heard what is this thing called copyleft. How do we deal with it? And there was a real education component to it. But fast forward to now, most of the major companies, all of them, are using copylefted software, and they know that they are. There's a general understanding about free and open source software generally. You cannot go into any company in the world and say the words open source and people won't know what you're talking about, right? We're in a world now where people know what it is. And unfortunately, that means that when companies don't follow those licenses, they are doing so with the knowledge of what those licenses mean. So the early days of enforcement are now really in the past, and what we have now is widespread use of copylefted code, but very little actual compliance. So raise your hand here if you have requested the source from a company. Some people who I've worked with are raising their hands, but this is like 5 people. This is amazing. Raise your hand if you don't know what I'm talking about when I've asked you if you requested source. So somebody's raising their hand. So I recommend to everybody, and there's a recording of this, so if you're watching this now, go ahead and take a look when you purchase a piece of equipment, anything. See if there are any notices about the software contained in the product that you purchased, and exercise the license. this is really important because when we exercise the licenses and we exercise the offers for source and we ask the companies to actually produce the source code, it means they have to, first of all, it sends a message of saying, we care about this. Enforcement matters, compliance matters, right? Getting the source code matters because we want to do something with it. These are not theoretical rights. This is an actual thing that we are supposed to be able to do. And so, so I'd say everybody, the other thing is that when only a few people and only folks like us at Software Freedom Conservancy are the folks asking for the source code, companies think, I can get away with it. And this is the current. And this is the current state, and this is what I think the abstract is referring to. My colleague Bradley Kuhn was supposed to give this talk, and so he wrote his own version of what he sees going on. But what I want to focus on is that right now we have this state where free and open source software really is in everything, it's everywhere, but we have a lot less freedom than ever before. We are a lot less able to control our own technology, and we're a lot less able to to exist in a world where we don't use proprietary software. So it's this very interesting situation where despite this widespread use and this widespread understanding of what these licenses are, they're not new, there's just this tremendous body of really useful knowledge that is under these licenses are available, but almost no companies are in compliance. Of the people who raise their hands, those 5 people, raise your hand if your general experience has been the production of complete and corresponding source code from your requests. No one is raising their hand. No one is raising their hand. And this is the current state of the GPL, which is that the GPL is an amazing license. It gives users rights. It gives people rights. It gives developers rights. When there is copylefted code, we know that we can do something. We should be able to get the complete and corresponding source code and the scripts to control installation and compilation, but we don't get that. And so what the GPL, what copyleft is a software right to repair, right? It's the idea that we have a right to that software so we can do something about it, so we can put the software that we want on those devices. And the history of the GPL leading up to this point is this really interesting time of we've established that this software is viable. We've established that companies can use the software, and we had some hard-won, some hard work that we did in enforcing the licenses to get them to where we are to where we are now. And yet, here we are in this time when almost no company is actually truly, or very few companies are in true compliance with these licenses, which is the very bleak state that is referred to in the abstract of the license. But lest you leave this too depressed, we have 6 minutes to talk about the future, to lift ourselves out of here, and to figure out a path forward. So I'm extremely excited because what's happening now is that people are starting to understand that they rely on software for everything. Raise your hand if you have had a conversation with someone who is non-technical, a family or a friend, who understands that there might be something weird about the software that they rely on, that they have expressed as hesitation about Facebook or Google. Raise your hand if you have, so some hands are going up. Almost everybody. Okay, good, because I didn't know what I was going to talk about next, because what I wanted to say was that we are in this time where people get the fact that there is something up with the software they rely on. They understand that these big tech companies that they have been relying on are don't necessarily have their interests at heart. And what we're seeing is this widespread comprehension about the need to repair our equipment, and that this is starting to translate to the need to repair our software. And we, in the free and open source software world, already have an answer of a technique that works pretty well, which is copyleft. And what we need now is to start the dialogue to say, what do we do with that? How do we get ordinary people to care about it? If every company received 20 requests for source a day, maybe 100 requests for source, the industry compliance would turn around overnight. Simple as that. As simple as that. If people cared enough to just ask. So when you go home today, look at your stuff. Look at your phone. Look at whatever you have, a television. You know, so we at Software Freedom Conservancy have filed a lawsuit in the United States against the television manufacturer Vizio. They're very large in the United States. And we filed that lawsuit as a purchaser. Like, we just bought a TV. But because we bought a TV, it came with copylefted software. That software gives us rights. And so we've gone into court to say everybody who receives copylefted software should have the right to be able to bring a lawsuit. They should be taken seriously by companies when they ask for the source code, not ignored, which is what has been happening so far. And so we're in the middle of that lawsuit, and I really was hoping to have some news by this particular, by this talk, but we don't have that yet. But this connecting of the dots between consumer rights and software freedom is not just a theoretical one, it's what it's all about. And because everyone has this, we have this new interest in our control of our software, I think we have this unique opportunity that we never had before. The other coda to this is that at the same time, there's quite a lot of, there's been quite a lot of lawsuits by companies, because as this software becomes more and more important and more and more widespread, companies dispute with each other over what the meanings of these licenses are, and ultimately those lawsuits have been creating the legal framework for which copyleft licenses are interpreted. And while and this is extremely difficult, because when courts around the world look at the disputes in front of them, they look at, who are these people in front of me? Who's in the right, who's in the wrong? Who's been hurt, who hasn't been? And the questions of the GPL often, or of the way licenses and contracts are interpreted, are often influenced by the fact pattern with which they're brought. And so I would say that never before has it been so important to have publicly brought lawsuits, to have public interest-based evaluation of these licenses. Otherwise, they will go, we won't have the licenses evaluated for what rights do they give us as a public, but instead will be, you know, what is right for this particular weird business situation, which will have ramifications throughout. So I would say that, like, as an activist for software freedom and as a lawyer who's been active in this space, I've spent the last decade getting more and more depressed about the state of the GPL, whether copyleft works at all. What will we do when the various LLMs strip the copyleft licensing off of all of our code and regurgitate it back out as permissively licensed? What will we do? And you know, but I would say that there is there's a lot of cause for hope now, because what we have is a software right to repair, and what we need is the ability to take control of our software as a public. And we are positioned now to push that forward. So ask for your source code. Questions? We have room for one question. Yes. Wait. Oh, okay, I'll repeat it too. 15 minutes is such a fun talk.
How do open source licenses or copyleft, how does it translate to LM models like GitHub Copilot? Because it is a derivative of definitely one or two.
Oh, you think so?
Yeah, that's...
It's fascinating to me because, you know, seeing how for Copilot that you raised is a perfect example, because for Copilot, GitHub has actually talked about the ways in which, for example, Copilot wants to insert the GPL itself. Like, Copilot wants to, right, and so GitHub has special cased quite a lot of these, or some of these times where Copilot wants to regurgitate copylefted material, it single cases it out, because the body of material that has been used for the training set. I have 29 seconds. I have to tell you this amazing story about how at Software Freedom Conservancy we got a phone call from somebody who said, hey, I didn't know who you are, but I was on ChatGPT. And ChatGPT, I asked ChatGPT to tell me who I should donate to, what organization should I donate to, And I had to push, but eventually ChatGPT said Software Freedom Conservancy. Donate to Software Freedom Conservancy. I have no idea who you are or what you do, but you're getting my $10. Thank ChatGPT. And it's because the training set is built on all of this copylefted material. And it's a real problem. I think your question was the comment. Thanks, everybody.
Thanks a lot, Karen, for your inspiring speech. Couple of minutes of break, and then we go ahead with the next speaker. Thanks a lot. Okay, welcome again. Second speaker, Federico Sartore from Panetta Studio Legale, and his speech is entitled AI Law and Ethics for Sustainability Corporate Governance. So very important topic.
Yeah.
So Federico, the floor is yours.
Hi everyone, I'm Federico Sartore. Today I will try to use these 15 minutes to talk about a couple of the most interesting topics in the legal world right now and how they can somehow underpin and foster some responsible innovation, and that's a very, very tricky endeavor, I have to say. I just briefly introduce myself. I was professionally born as a lawyer, as an attorney of a Panetta law firm. I'm working with, it is one of the most famous law firms in the very narrow field of privacy and data protection. So I had the chance to work with a lot of big companies, a huge organization all over the market spectrum. So I had a chance to, in these years of the GDPR and what connected to know a bit more on how these words work. And then a couple of years ago, 2021, I founded with a couple of friends, philosophers and tech people, Dexai, Artificial Ethics, that is a startup dedicated to implement AI ethics into real-world processes to, let's say, extract the value from our experience in the EU level with EU-funded projects, working with the EU Commission, working with standardization, let's say, panels. And so what we think is that what I want to transmit to you today is I'm not speaking about AI from tech perspective. I just want to give you a couple of, I hope so, insights of being most of the people here with a technical background. I think that you should know what we are talking about when you are talking about AI ethics and AI legal framework, because there are a lot of opportunities to be exploited from a technical and business perspectives. Today, I will go through this presentation, but the most important concept is that at the moment there's a huge confusion about how to regulate AI. AI is big, huge, it's the real promise, everyone is super excited. Most of the people who are excited have no idea what is AI, what is behind AI, and so on. But it is now becoming more and more a central topic, not only for businesses, but also for governments. We are in the midst of a very peculiar geopolitical fight between US as main innovators, China as the rival who has a lot of great access to data, to information, and in the middle we are a European Union, and we cannot fight with the same weapons of both Americans and Chinese. So the EU, let's say, goal is to regulate, is to create an environment for a responsible development of AI practices. So it is in the field of rights and fundamental rights that the European Union is now trying to work. So basically, the point is that we have to regulate this phenomenon that is very complex and really fluid and is moving quite fast. The first concept I want to give you today is that a lot of rules already exist, and they are perfectly fit to to regulate AI. For instance, data protection regulation is completely and fully applicable to AI, and the full application of privacy and data protection regulation can lower the risk for individuals in the, let's say, subject to AI decisions, for instance. A lot of criminal law, civil law, there's a lot of rules. So the point, in my opinion, is that there are too many rules, and the new AI Act that is forthcoming, it will be, I think, we had some conversation last days, I think by the end of the year, it will be approved, and at the beginning of 2024, the final approval will arrive, and after that, 1 year or 1 year and a half of a grace period, and so 2025 or 26, we will be in the era of, we enter the era of the AI Act. But everything about regulation is that nobody knows how and what to regulate. So at the moment, it is a big empty box, super structured with a lot of rules, so with a lot of concepts. But what I'm aiming to do today is to, let's say, push you, to encourage you to act, because at the moment there's a lot of room to regulate, to be proactive. If you are part of an organization, or if you are a developer and you are from the academia, at the moment the regulation is basically a big empty box, and we all have, let's say, a duty, but the opportunity to fill that void. AI ethics, in my opinion, is one of the contents that may be super useful to be put into this box. Because, you see, the point with the rules is that people will, in general, will follow a rule only for two basic reasons. The first one is that if I do not follow the rule, I get punished. And this is a very, say, basic, say, legal. There was a philosopher, a legal philosopher, Kelsen, that had this idea that a rule without punishment is not a legal provision. So, or either you are punished by not following, if you're not following the rule, or you are getting an award if you are following the rule. If your balance is 0, you have no reason to follow a rule. So the regulator in general tends to follow, unfortunately, the first approach. So all the compliance word says you have to comply. If you're not compliant, we will check. I will come after you, and I will punish you with pecuniary fine, with other kind of punishments, and so on. We think that the AI ethics is a way to see the same problem but the other way around. So with implementing a number of concepts and principles that we'll see, we want the AI technologies not to be neutral in terms of a set of values behind it. Of course, we will not enter into the field of this debating of what are the common values that we want to teach to the machine, or we want the machine to respect. We give or assume that in the European Union we have a common set of values, of important principles that we want to be protected. For instance, non-discrimination, human rights, environmental protection, privacy, security, and so on. So we give that for assume, but in general, you may find another legal or geographical system where these rules are slightly different. And we want both with my legal, let's say, soul and more entrepreneurial one. So as a startupper, we want to, make this process that you may find very abstract, very theoretical, super practical. So I'm not saying that is an easy task, because most of the development in this field is coming from the academia, where people want to write paper, write groundbreaking things, very theoretical and general. What we're trying to do is to use the ESG principles, that stands for environmental, social, and government, to translate the AI ethics principle, that those that I mentioned before, the fairness of an AI, the bias mitigating methods of an AI, into some numbers, KPIs, something that can be, let's say, scientifically observed and described in order to put into the your in general, but the strategy of an organization in an objective way, let's say, in terms of ESG strategy. So if you want to be good, you will be awarded for being good, and you are developing a good AI, and you are buying a good AI, and so on. That's why as tech people, as developer, if you are setting, let's say, if you're working on the ethicality of your software, and I think in the free software context, in open source context, is super important. You're adding an actual additional trait to the software. Is not something optional. It's optional, but it's not something without a value that can be societal value, economic value, but is an actual feature. Being run through ethics assessment and checks process gives more value to an AI tool, an AI extension, whatever. It's not so important. So basically, yeah, these are the three main criteria on which we worked. This is not, let's say, This is not a commercial pitch, it's just an example that I want to give you, but I think that there are plenty of room to express yourself, to debate, to create new processes in embedding AI ethics into, let's say, a way that is not impairing, is not hampering because we have a lot of discussion with developers, and of course, they do not want to add layers of structure, of complexity in their work. They want to be fast, they want to be efficient, and so on. So our work here is to teach basic concepts, basic principles, and find a way to make them operational without, with, let's say, a positive-sum game, without impairing too much without creating too much red tape structure to bureaucracy and so on. This is really a very, very basic example, and then I will leave a couple of minutes to your question. In this kind of report we developed, there's a mix of what I said, so legal and ethical principles transformed into actual KPIs that have scientific validation coming from the academia and can be spent in a number of ways. You can just tell them to your family when you go back home, I developed a responsible AI, and these are the numbers that demonstrate it, or you can move to, you can go to the board of the organization and say, we are not only creating great innovation, we're doing it in a responsible way, and this is measurable. You can use it to go to a bank and ask for sustainable, let's say, financing because you have some numbers to show it, and it is developed in a, say, standardized GRI standard. I have no idea what it is, but they told me that is how ESG World works. Yeah, and I will leave a couple of minutes for your question if you have any. Otherwise, thank you a lot for your attention.
Thank you, Federico.
I think there's...
Yes, there is immediately one question.
Today I had two options, my outfit as a lawyer one or startupper, and I forgot the legal trousers, so I had to come with this more informal outfit. So
not a problem. Not a problem. We are lawyers too.
Okay.
So no, in practical terms, how would this translate in something rewarding a company or an entity doing ethically? You think of a trademark or a quality mark, or stating that you are ethical, so you have more success, or you think about a some certification that alleviates somehow, from a regulatory point of view, the regulatory burden that you have to certify or to pass certain tests. Which kind of consequences you envisage for this?
Yeah, I'm giving you a couple of examples. We take the AI Act and we say, okay, we are assessing the alignment with a number of points. For any element of alignment, there's a score, and it is weighted against the importance, and with a very basic algorithm, we elaborate a score, and under the score, you can describe in a synthetic, more practical terms, your level of compliance in the ESG world. Or with ethics, we suggest to do the same, to take a general principle, for instance, fairness or trustworthiness of an AI system that is broken down into subsection and to go through each of them. But with trademark, you can do the same. The point is that you have to build a kind of a connection between the subject matter and the AI realm or the environmental social governance realm. But yeah, I really suggest you to work if you are in the legal and the academia, and to work to fill this empty box and to solve this regulatory conundrum. So I think we ran out of time. Thanks a lot.
Yes, thanks a lot, Federico. I think you can still continue the discussion. So in 5 minutes, we will start with the next speaker as usual. Thanks a lot. Okay. Next speaker, Luca Bonissi with his company Bonix, and I think we are going to talk about Windows. So Luca, please, the floor is yours.
Hello. I'm presenting myself a little bit. I live in Italy, and I work. My main job is a firmware developer of embedded devices. I have some hobbies, audio and video. I play the guitar. I observe celestial objects, and some 3D printing. I write some free softwares, like play your chords. It means that you can transpose the chords automatically of songs. I follow the unofficial distribution of Slackware for many platforms. And I'm developing a free Android TV box. Means that I remove Android from the TV box and installing Bonslack, that is the unofficial Slackware distribution. I write a little tool for the Free Software Foundation Europe that helps translators to translate the pages and the activities of the Free Software Foundation Europe. And I translate together with Francesco Indorato and other people from Italian community, the book Ada and Zangeman, that today is launched in Italian. It is available at the FSF booth. Okay, as I already said, there are many translations of this book, fantastic book, and since at 6 o'clock, the closing event, there will be a reading from the author, and this book talk about also the right to install any software on any device. So is very related also to the Windows stacks. And this is an hobby. I make ice cream, and you can find the ice cream at the FSF booth. Okay, we start with the legal basis. There are two different contracts. When you buy a PC that comes with pre-installed Windows, there are two different contracts, hardware and software contracts. The hardware is you buy the PC, so the hardware is finished, the hardware contract. Instead, the software contract is not yet finished, and it will be finished only when you click on the agree at the first start of Windows. And also these two contracts are from different actors. One is the company where you purchase the PC, and the other is the manufacturer of the PC. And usually they are different. And obviously the agreement comes in two different moments. So the two contracts cannot be merged because many manufacturers try to link the two contracts. So if you don't agree to the Windows contract, Windows license contract, you have to return the PC. But this is not legally correct. So I also, as said before, you have the right to install any software. You should have the right to install any software on any device. And because in this way you can control your devices. And you overcome, for example, software obsolescence. Android, for example, that maybe from your device that could be not updated because the manufacturer doesn't release any update, you can install a free software alternative that has updates, so your device can still live even if it is old. Okay, there are some technical hurdles with pre-installed software. Some manufacturer says your product doesn't work with an operating system different than Windows. And this is partially true. For example, the Microsoft Surface laptop, the touch screen and the webcam doesn't work with Linux, the first version of Microsoft Surface. And the manufacturer doesn't give you support, doesn't give you the specification of the device driver and so on. And some manufacturer uses proprietary interface, such as the keyboard and touchpad for the Microsoft Surface is not standard. Someone uses the secure boot to lock the boot process, so you cannot technically install. This is true for some version of the Microsoft Surface pad with an ARM processor. Okay, manufacturer say that you have to ask the refund to the vendor, but the contract is very clear. You have to ask the refund to the manufacturer, not to the vendor. Some manufacturers say that you have returns also the PC, but as I said before, so hardware and software contract are different contract, distinct contract, cannot be joined together. Manufacturer sometimes say that you must prove that you refuse the license, but when you start Windows, the first time Windows, you don't have the refuse button, you have only the accept button. So you cannot prove to refuse the license. And sometimes manufacturers say that you must follow their policy, even if you don't have seen any contract with the manufacturer. So, for example, the manufacturer sometimes request to return the PC to remove the Windows OM key product. And the price of the license is self-determined by the manufacturer. So, but this is wrong because the license is the market license, so is not good. Or sometimes, for example, for Office, they say the license is gratis. Is free, but it is not true because they do not prove that the license is gratis. If it is gratis, they will give to all. Okay, when you start your PC for the first time with the Windows 11, you must connect your PC to internet. Sometimes you have to wait that the upgrade become true, and I don't know how much this is privacy safe, because you send some information to the manufacturer and to Microsoft, but you don't have accept any license, any contract. As I said before, there is not the refuse button, and you cannot install a different license. For example, if you buy a full Windows license, you cannot install because the installation program of Windows automatically detected the key inside the BIOS and install the license you found in the BIOS. Okay, the first case in Italy was Marco Piraccioli that versus HP that go to the Supreme Court of Italy, and HP was the final verdict say that HP must refund the Windows license. Okay, I go fast. There are many cases, you can find them in the slides. Also, I requested many cases. The one interesting is against Lenovo, when I bought this PC. This one is in 2018. And Lenovo refused to give me the refund. I started without a lawyer. I don't know how much was good this choice, but I started the first grade without a lawyer. But Lenovo introduced so many complexity that I must ask for a lawyer. Then Lenovo, I win the first grade, even if I pay more my lawyer than what I receive from the judge, the verdict. Lenovo immediately filed the second grade lawsuit, and the judge this time imposed to Lenovo a punitive damages amounting 20,000 euros because he said that Lenovo abused the appeal procedures. Okay, any other case, I go very fast, you can say in the slide. There are many cases, but I think it is important to report this unlawful behavior of the manufacturers. And so as you can find at point 7, report the incidents to the antitrust authority of your country. This is very important because manufacturers are feared from this, the antitrust authority. And finally, I think that what was taken from free software should return to free software because when you buy a PC with Windows pre-installed, some money, and not only money, some control, some sovereignty is stolen from free software. So if you get a refund, please give a part of them to some free software. Okay. A little spot, if you want to become a supporter of FSV, you will give a book, an Italian book of Arend Zangeman for free. Okay, finish. If you have any question, 30 seconds.
Thanks a lot for this nice history about all your personnel. We have 30 seconds, but I don't have time for one question. I think in case you can, let's say, explain more about your personal experience to all the interested persons. So in 5 minutes, we go ahead with the next speaker. Thanks a lot. Okay. Next speaker, again from the Software Freedom Conservancy, Devan Gingerich, and we are going to speak about GPL enforcement. Denver, the floor is yours, please.
All right, so I'm Denver Gingerich. I am the Director of Compliance at Software Freedom Conservancy, and I'll jump right in. So first, why are we here? Well, we're here for freedom. We're here for the freedom to repair, modify, and update our device software and hardware, but I'll talk about software. So this is a quote from an email that I sent to a company that we're trying to get into compliance. And importantly, what we said in this email is that the GPL is not a silly make-work license. It requires the companies to provide these rights to repair, modify, and update our device software. And in particular, what the GPL says, GPL version 2 used by Linux and other programs, is you need the scripts used to control compilation and installation of the executable. So how do we do this? How do we do this enforcement? So first of all, we receive reports of GPL violations. People send those to this email address, compliance@sfconservancy.org. Then we triage those reports. So we determine if GPL binaries have been distributed, and then if they have, we determine if there is any source code or offer for source code along with those binaries. Then if there is an offer for source, we check that offer. So we request the source code from the company per the instructions in the offer. And if there is not an offer, then we have to contact the company because there is already a violation in that case. So when we receive this source candidate, and I'll call it a candidate here, you'll see why in a bit, we do a CCS check. So that is determining whether this source candidate actually is complete and corresponding. So usually what happens is it's not, and then we need to go back to contacting the company. And we usually have to do this a lot of times. It's not uncommon for us to have to do this a dozen times for various things, and it's very frustrating. So sometimes it does work. So in that case, we get it to the users. So we tell the company, contact everyone who you've distributed these binaries to and tell them that source code is now available because it wasn't before. Or we have to file a lawsuit. And this we do not take lightly, of course. This happens if the company stops responding to us, or if they just say, no, we're not going to do that. We don't have to comply with the license. So for example, as Karen mentioned earlier, we filed a lawsuit against Vizio, the TV manufacturer, because they just stopped talking to us despite our repeated requests for them to respond and fix the source code. So now to get onto what a CCS candidate, or sorry, a source candidate is, and the CCS check. So there are a number of source candidates that we have now published on our website, actually. So I'm going to use this opportunity to pre-announce this project called Use the Source. So you can go to this website, sfconservancy.org/usethesource, and you can see some of these source candidates that companies have provided and see if they work or not. So you can try them out for yourself. You can try compiling them, try installing them if you have the hardware, and see what it is exactly that we do here. So you can do that right now if you want, or you can keep listening if you like. Let's break down what a CCS check is. So again, we are looking for the scripts used to control compilation and installation of the executable. So therefore, we want to know, does it compile? Does it have the scripts used to control compilation of the executable? And does it install? Same thing for installation of the executable. And also, from another part of GPL version 2, is it the complete corresponding source? That is, for all of the stuff in the binary that has been provided to you, do you have source for all of those things in the binary, including all features that the binary may have? So first of all, does it compile? First, we look for a README file, which may tell us how to do this. If one doesn't exist, then we just try make or other standard things. The README may tell us you need to use a certain operating system. So sure, let's try that. And then we'll start to see if we can compile it. Now, what happens more often than not, unfortunately, is we run into an error. And you may be wondering, is it my fault? And the answer is no. No, it is not your fault. If you followed the instructions, it is the company's fault because they provided you with incomplete source code because you're not able to compile it. So perhaps it does indeed compile, that would be great, and you get a firmware image. So let's move on to the next step. Does that firmware image install? We'll look for that README file again, see if it has instructions specific to how to do this, and we'll put that into an update user interface, for example, if that's what it tells us to do. And then perhaps it works. That would be wonderful, but it doesn't quite get us all the way to what we want. We want to see if we can change something and then have it still work. So let's do that. Let's maybe change a version string or something more substantial that you'd been wanting to do anyway. And let's see if it still works after that. So maybe it does still work, but sometimes that doesn't happen, and instead the device is bricked. So again, is this your fault? No, it's not. It's the company who provided you incomplete source code. And so if you're concerned about this, I'd recommend checking with someone who's tried to do this on the device already, because you don't want to necessarily brick that device. So maybe it did indeed work. And now you need to check, well, is that actually complete and corresponding? Because maybe you installed something onto that device, but does it actually match what was provided by the company? Does it have all the same features? So first of all, one of the big things we run into is these proprietary kernel modules. And whenever something is derivative of Linux, it must be released under GPL v2. So that would apply to these kernel modules. So that is not allowed. They need to provide the source code for the kernel modules. Now we need to check for other things. So is there say, user space applications that are installed? We need to check again if those are derivative of any copylefted software, and maybe they're not, and maybe they are in compliance with the licenses in use, but we need to check that. And then lastly, we determine if the software that has been generated in that compilation step, is it similar to the stock image that was provided by the company? So there's a few ways we can do this. A couple heuristics we use. One of them is to check the file sizes, see if they're similar, and also the strings that are in the binary, say using the strings command. And importantly, we're not yet at a reproducible build situation where we could check for bit reproducibility, so we need to use these heuristics instead. Now, if that all checks out, then great, we have a complete corresponding source release for this product. If you find one of these, please let me know, because it is so rare that we find these. I would really like to know. Email me at compliance@sfconservancy.org. So now, to go back to some of these things I mentioned, does it compile, does it install, does it correspond? Usually the answer is no. And so what do we do in that case? Well, we contact the company. We at Software Freedom Conservancy do that, and then we try really hard. We contact them repeatedly through different methods, and we ask them for the source code, tell them what their obligations are. And then sometimes, as I mentioned before, if they stop replying to us, or if they say, no, we're not going to comply, then we need to file a lawsuit. And again, we're not trying to get anything that they haven't already agreed they need to produce. They chose to use Linux, they chose to use things under this license, so we are just asking them for what the license they chose to use says they need to provide. Now, what can you do? You may be wondering. So as Karen mentioned in her talk, please check your devices, see if there are any offers for source code, because it would be great if you asked for the source code from those. And if you like, then you can also do a CCS check on them. And once you've done that, let us know how it goes. And even if you're not able to do a CCS check, let us know if they did respond to your source request. If they did provide anything, we could put some of that on the Use the Source website that I mentioned earlier. So those are the things that I would recommend doing. Now, I did want to just briefly mention some of the other possibilities beyond this. There are various ways in which individuals can use legal actions to get the source code themselves. And so there are different ways. For example, with Visio, the lawsuit that we're doing against Visio, we are filing it as a third-party beneficiary, so where you're not asserting any copyright claims. And if we succeed, then it will show that anyone could do this sort of lawsuit, regardless of whether they own the copyright in the code. And so this is a very important way that we're hoping to be able to pursue these sorts of things in the future. There are also, for example, in Germany, there are warranty claims that some people have brought, which is another good way that we can get individuals involved in enforcing. Now, if you do want to do this, maybe chat with us just so we can coordinate a little bit, but just so you know, there are options out there. I also just wanted to highlight, as Karen mentioned, Harold Velta has done a lot of work in Germany on GPL enforcement. He told us he's not currently doing that sort of work, but we do hope that he can in the future, so we can get past some of these roadblocks. Although things have changed a lot, companies are much more entrenched now, and so we are concerned that it will be difficult even if he starts doing that again. So anyway, I wanted to open it up to questions now. There are some of the resources that I was mentioning here, and you can always email me at compliance@sfconservancy.org if you like. And looks like we have 4 minutes or so for questions.
Thanks a lot. Questions? Yes?
Okay. Grazie. So my question is, I'm passionate about routers, and I like to play in that camp. So what happens when the vendor provides the code and everything is all right, but you cannot install, for example, the image, the firmware image you provided, because U-boot, which is not under GPL, is actually checking for a key you don't have. Is this violating the GPL? And furthermore, in some cases, like a Broadcom, for example, you never get the complete code of the proprietary kernel module they use. You get some of the code and some .o files. But this is happening for years, so I guess that this is okay with GPL, or what happened here? Thank you.
So the answer is no. None of those are okay per the GPL. We need more resources in this, frankly. Conservancy is doing as much as it can in the lawsuits it's filing. But yes, these things have been going on for years, and there has not been enough enforcement. So both of the things you mentioned, installation and these keys, like GPL v2 doesn't talk about keys. It just says all you need is the scripts used to control installation. So you should be able to install it, regardless of what keys might be involved. And on the proprietary kernel modules, as I mentioned, we would expect the source for those for all kernel modules. It is not legitimate to have proprietary kernel modules. Any other questions?
Yeah, I just wanted to ask, is there a way to dilute GPL license by modifying the source code in any way? Or in other words, if all Linux derivatives have to be open source, how does macOS get away with being closed source?
Are you saying that macOS is a derivative of Linux?
It is based on a Linux kernel, isn't it? No, it is not? Okay.
Let me know if you find evidence of that.
No,
I would like to know.
But in that sense, is there a way to dilute GPL to an extent that you can make it closed source? If I base my code on anything under GPL and modify it to a certain extent, is there like a limit where it can become closed source?
So to be clear, I'm not a lawyer. Nothing I say is legal advice, but I don't think so. Like the license says what it says, and if you're distributing it, then you need to do so in compliance with the terms, including any derivatives of that. I think we have time for one more question, perhaps. Any other questions? If not, then I'll make a quick pitch. Please become a sustainer for Software Freedom Conservancy and check out these resources here. You can see how to help us out at that URL there, and the slides are all online. And please check out Use the Source. If you have any comments, please let me know at compliance@sfconservancy.org, because we plan to publicly, formally announce it in a week or two. So if you're poking at it and have any questions, or if you'd like us to add any source candidates that you found that you think might be interesting to include on that website, we'd love to hear about that. You'll notice that there is one candidate we found. This is actually the only one we found that is in compliance with the license. And then the other ones are all not in compliance with the license. And we expect any others that we would add would probably be in that boat, but we'd love to know if there are other candidates in compliance. So I think that's all from me. I'll be around at the rest of the conference if you have more questions, and thanks very much for your time.
Thanks a lot. Okay, short break, some minutes, and then we start again. Okay, so we can start again. Our next speaker, so we have two speakers, Alberto Pianone and Carlo Piana, and in 50 minutes they have promised us to explain how the Cyber Resilience Act is going to change FOSS. So please, I'm really interested in your presentation.
Good afternoon. If I can have my slides. Know your code. Yes, KYOS, KYC, yeah. So, Carlo Piana, Alberto Pianone. A dark cloud is coming, and this cloud is called CRA, which is short of Cyber Resilience Act. We have heard of it passing this morning from many, Simon's one. So it's something that is going to impact you. It's going to impact open source because either you will be considered a distributor, or if your open source product or software is going to be used in production, you will be a viable or non-viable according to complying or not complying with the requirements. Under CRA, you have to do a lot of things, and you will be compelled to know your software and let it be known. That has different angles. First, provenance, from where your code comes. Not just from where you are downloading, but the first upstream source of your code. That's important. And also, integrity, whether your code has been changed in the process by somebody. Supply chain hijacking is a mounting problem in software. So knowing that everything has flowed and how has it been changed through the process is important. That begs a question for security. CVE scanning, whether patches have been applied correctly, and if those patches go to the image you're building. And not just by the time you are distributing, but if the software is going to a product, a software-enabled product, that must be maintained and taken care of for the foreseeable duration of the product downstream. So this is not just, oh, you should be. No, this is going to be an obligation or something which is necessary for making your products, your software product, viable for the market, viable for any meaningful use, not for hobbyists. Especially in the embedded software, which is the angle we have and the field we have been doing this. So the only choice you have now is to take the plunge and start doing that. Because if you start tomorrow, if you start when the CRA is in force, that is going to be too late. And good luck finding good resources for helping you if you're not able to do it yourself. Because all the resources will be struggling to cope with the deadline. We have done it. We have experienced that beforehand. So in this Eclipse Oniro version 2, we have done it, and we have accomplished something which is very close to what I'm speaking about. Eclipse Oniro is an operating system for embedded software. We are helping them in a continuous compliance way. So we have prepared, we have completed a complete tool chain for this. Everything based on free and open source software, including Fossology, including scan code and other elements. And we have developed a set of tools going by the name of Aliens for Friends, which is Alberto is going to take the most credit for it. And we are able to prepare to produce a software bill of material in a machine-readable way using SPDX, of course. That's our choice. The actors in display are, well, Array, which is us, and Noi. You can have already heard of them somehow. I don't know how. So one picture is worth 1,000 words. So this is how this is the dashboard for it. So you can have a visualization of the packages, and you even can dig deeper and have information about the single packages, their provenance, and many information. So, oh, sorry, this is not anymore. I've completed my part. Handing over to Alberto.
Thank you, Carlo. So, as Carlo said, knowing your software, knowing what's inside your device, your marketing, is a key element for the compliance with the future CRA Act. This is one of the aspects of CRA compliance, but it's the main aspect or the starting point, because if you don't know what's inside your code, you cannot comply with all the other obligations of the CRA. So this is a common starting point for any kind of compliance, basically software composition analysis. The thing is a big issue in the embedded world, because in the embedded you don't have usually standard Linux distributions. You need to cook your own distribution, because there is this hardware integration issue that is a pain for developers. So you always need to refactor things in order to make them work in a specific target device. To do that, the most commonly used tool is Yocto. There are other tools, but Yocto is the most comprehensive and complete tool to bake your own custom Linux distribution. The thing is that you have a lot of flexibility using Yocto. You can use recipes, layers of recipes. You can override anything at any point of your build process. But this flexibility brings a lot of complexity. So this complexity reflects when you need to generate the software bill of material, when you need to know exactly what's inside your firmware image. The problem we faced with Yocto is that it makes a great soup, but how do you trace ingredients when you already mix them in the pan? I mean, with Yocto, you have recipes, and we notice, for instance, that developers are allowed to, I don't know, for instance, override or even patch upstream code, and but this goes unnoticed in the source package that is created by Yocto, because it seems that the patches or the new the added source code files come from the upstream, while that they are actually downstream additions. And this is an example. There are other issues we found while working on Yocto. And so we tried to think about a solution. So we started by looking at Yocto's workflow. Here you have a lot of ingredients. So you can have one recipe intended to build one component, but you may have more than one ingredient used to build that component. And basically, those ingredients may contain various issues, license issues or security issues. But the thing is that everything is mixed together. You got the binaries that are installed in the image. And you may end up in having bad things you don't realize you have in your image. So what we've done, so the idea was to map upstream source files to local workdir source files to binary files. So to trace the whole process from the upstream to the local workdir to the binary image. So we wanted to consume metadata from Yocto, and we wanted to trace the unpacking process within the Yocto build process. So in order to divide the ingredients before they got they get mixed in the soup pan. That is the local work tier where you build everything. First, we tried with a downstream approach just to have a proof of concept. This was done last year. We tried to inspect Yocto builders in order to get this kind of information. But we realized that the solution really needed to be pushed upstream. So we worked a lot. It took 1 year, half of the year was passing convincing the Yocto team that the thing needed to be done and discussing how to do that. And another half of the year, we needed to really try very different solutions because we needed to patch the inner core of Yocto, of BitBake tool, that is the cooking tool of Yocto. And but after all this work, we made it. So this is fresh news. Our patch has been accepted in Yocto. And you have it if you download the latest release 4.3. You have our patch. It exposes an Unpack Tracers API where you can plug in your logic to trace individually each upstream component, each ingredient, before it gets mixed into the work tier of the recipe. We also have developed a first implementation of this API that consumes actually this API. If you want to collaborate, if you're interested, if you are working in the Yocto field, any kind of help is welcome because we need test cases, we need developers, we need adopters, users. And so we will also work on backporting the patch to older Yocto LTS releases. And we have 3 minutes for questions or if...
Questions?
Okay, if there are no questions, unfortunately, 3 slides have jumped off. I didn't realize. And I had to tell you that I was quickly browsing through the text of the CRA, and I give you the references. If you find the material online, you will find them as well. The most important provision is 10.4 of the last available draft, which is, says that manufacturer shall exercise due diligence when integrating components sourced from third parties, which is software you take from others and software others will take from you. That works in a chain. Annex 1, products with digital elements shall be delivered without any known exploitable vulnerabilities. If you don't know the Wallis Circus code, how can you check them and know if there are known exploitable vulnerabilities and if they have been patched? Annex 2 refers to, point 6 refers to bill of materials, which is a concept we have used. And if anything goes wrong, there is a surveillance authority who can demand to receive the bill of material and information as to check compliance with the essential requirements in Annex 1. And this is not something that you can produce in a matter of days. It will take months probably. And so this is another provision under which you are forced to know your code and let it be known. And of course, if you're in critical products with critical products or high-risk AI system, the requirements are still stricter. So that's all I wanted to say. Thank you.
Thanks a lot.
Oh, there's a question.
Yeah.
Rafael.
Wait.
Wait for the
mic. Wait for the microphone in that sense.
Yeah.
So the question is the CRA already in force, and until when do vendors have to comply with it?
It is not yet. It's probably, as we discussed it this morning, probably has been discussed in the trialogue, or it's going to be released soon. And of course, there is going to be a an implementation phase. So 18 months, I think, from the last, or 18, 24 months. But it's going to be, sorry? 36. Oh, that's too much. But it's going to be anyway. If you start late, you will never finish.
Yeah. So it seems that the toolchain that has been developed could be helpful in that regard. So that's the message that I somehow have understood. Okay. So, but let's close here the discussion. Of course, you can have follow-up discussions. Couple of minutes, and then we go on. Thanks. Okay, so let's start with the next speaker, Davide Ricci, who is going to present his work at Linaro. Davide,
Hey guys,
the floor is
thank you for
yours.
joining. Can you hear me? Yes. So my name is Davide Ricci. I'm the director of the Qualcomm's Developer Services at Linaro. And I'd like to drive you today through the evolution of Linaro as an organization from the beginning to addressing continuous compliance in production grade systems. How many of you know of Linaro? Okay, so half, I would say. Okay, so we're going to start by taking a look at the review mirror, how Linaro was originally created, and the scope of the organization. And then we're going to take a quick look at the compliance expectation in Linaro at the very beginning. Then I'll drive you through an evolving set of requirements that are going to drive changes in the organizations and the company, moving from, if you will, collaborative engineering in upstream toward production grade open source and continuous compliance for devices of device makers. And hopefully you have questions at the end. Okay, so what is Linaro and why Linaro was created? Linaro was founded in 2010 at Computex was the initial announcement. It was, I'm quoting, created to provide new resources and industry alignment for open source software developers using Linux. The general idea is that at that time, ARM, and today ARM had many licensees, and then the ARM architecture and subsystem in the Linux kernel and GNU toolchain was inexistent. And so you can picture many SOCs and licensees of ARM trying to enable that basic architecture supporting kernel and toolchain and try to do the same thing over and over again in a different way. And you can picture Linus Torvald and the kernel maintainers see many patches coming their way pretty much doing the same things. And they were like, what the hell? Right? And so at that point, ARM was like, okay, what, stop. This is really fragmented. Let's try to create a collaborative engineering organization, Linaro at that time. Let's try to get us, all on the same table, SOCs and licensees, and build the non-differentiated value ARM technology in open source. That was the original idea. And so Linaro was created to be a collaborative engineering organization, meaning that we create technology and standards. We foster open source engineering excellence. When it comes to engineering, it's mostly an engineering-driven organization. And then the general idea is to reduce fragmentations and cost by sharing resources. Okay? So these were the origins. And so the initial areas of focus, you could probably imagine where Linux kernel, toolchain, GNU GCC at that time, LLVM today, bootloader, QEMU simulator. Of course, QEMU is general enough that can be a collaborative engineering effort as opposed to a specific SOC simulator or emulator, and then the necessary infrastructure to perform continuous testing in CI. But again, in this specific instance, testing in CIs are meant to make sure that a work that is done in upstream, tracking the development, say, kernel tree, doesn't break any of the functionalities and does not introduce any regression. So it is testing in CI mostly for regression testing and to avoid things to blow up, right, in your face. So this has led us, I would say it's a box that we ticked, has led us, if you look at the statistics, to consistently be the #1 contributors to the Linux kernel and mostly focus on the ARM architecture and subsystem. I've just taken a snapshot from LWN mailing list and statistics blogs from, I think it's 6.3 kernel. And then on the right top side, you have the contributors from 5.18 to 6.3. And you can go back, as much as you want. But in the past, I would say 3 years, 3 years and a half, Linaro has been consistently up there. So that's great. But it also means that, I'm not saying the job is done, but now it's about maintaining the work that has been doing so, that we've been doing so far within the ARM ecosystem. So the question is, what's next? Right, so if you look back again at the very beginning of Linaro, right, and the idea of building a collaborative engineering organization, and I'm going to start driving into compliance requirements, the organization was mostly built around 80% collaborative and 20% dedicated, meaning that if I'm an ARM SoC vendor and I work in a collaborative manner with all of the other licensees at ARM to enable the ARM architecture in open source, I might, at some point, need Linaro services to build my specific SoCs, open source, upstream roadmap, but that is really, kind of a teeny tiny tip of the iceberg. Most of the work was around collaborative engineering. So if you collaborate in a collaborative engineering expectation, what is the compliance expectation that you have, right? So most of the work is done in upstream, and most of the work was done with upstream first mindset, as a matter of fact. And then if you do not, Carlo and Alberto are here in first row, but if you do not host nor redistribute code, what is expected of you? If not basic training for IP and FOSS compliance, and maybe the selection of friendly licenses for collaborative engineering. Whenever there's no hosting or distribution of code, nor integration or packaging effort, and all the work that you do is on Linux kernel, new toolchain, QEMU, you follow the license of the upstream project, and you just got to make sure that your engineering, skills are complemented with IP compliance and FOSS management. And that is about it, right? Carlo, Alberto? And I think that's been such as that until very recently and very now. Right, so past the initial areas of focus, Linux kernel, toolchain, bootloader, QEMU, and testing in CI, then Linaro's activity in open source has evolved over time. And then, kind of same recipe, moved the focus to security, trusted boot, trusted substrate, secure boot, payload, from bootloader all the way to signing packages, AIs, as AIs accelerator become available in technology, enabling them as a generic technology in a collaborative engineering effort, and then RTOSes with Zephyr, right, similar to what's been done in Linux. But then again, and I think more importantly, and this is what's driving the evolution of the company, from upstreaming to integrating, downloading, packaging, redistributing, and hosting, Android and AOSP, and automotive, edge, and industrial IoT distributions and solutions, mostly based on Yocto, OE Core, and Debian. So now if I'm one of the IP auditor or lawyers in the audience, I'm thinking, oh, you're distributing software now, or you're packaging releases. That is a completely, different game, right? It's a different ball game, right? And of course, this drives requirement for more compliance and the evolution of compliance at Linaro toward continuous compliance. All right, so of course, this evolution is driven by a couple of things. First of all, as we have ticked the box around Linux kernel, toolchain, bootloader, generic technology that you can achieve by collaborating in engineering, right? You start moving from upstream, if you will, to downstream, or from upstream to production grade systems, right? So you serve SoCs vendors, but you start serving more device makers who are the SoCs vendors, customers, right? And so that's kind of the evolution of the customers, if you will. And then if you look at the bottom of this slide, you see that initially on the left, there's Linux, toolchain, QEMU, U-boot, and then the requirement for dedicated engineering, for compliance, readiness, or for CI and CD and DevOps is minimal, as I've described so far. But as you move toward SoCs, security, AI, Yocto, Debian, AOSP, and packaging, the need for compliance readiness goes up. The need for CI and CD and DevOps, beyond just testing that you don't break anything, goes up as a service hosting, for instance, public and private benches. And then the need for dedicated engineering goes up, moving from SoC, collaborative engineering, and complementing that with dedicated device makers engineering and production-ready OS images. That's kind of, hopefully gives you an evolution of where we are, where we're going. And then the strategy at the same time changes as well, right? So now the infrastructure, as opposed to just become, being a tool to make sure that what you do doesn't introduce regression into your upstream collaborative engineering work, becomes the center of the overall, three-legged stool. And I try to draw and us too, but frankly, it's impossible. So I actually ended up with, and I know, it's just like, that was the feedback I've gotten. Yeah, I think this explains that the infrastructure is core and center, and then you have the upstream collaborative engineering circle or layer right after that. And then what is common across the collaborative engineering project, maybe you can think about a product. When you think about product, you think about packaging, you think about compliance, envelope, start thinking about those, and then developer services and dedicated services, and now you're moving into tailoring images and having to tailor compliance envelopes and artifacts and standardization artifacts and certification artifacts to the need of the device makers that bases their products, bases their OS images off your products and off your upstream and off your infrastructure. So infrastructure, upstream, take down, build products, customize, build services. This is an even different ball game than what I've described so far. So what does that mean in terms of compliance? So moving to production grade open source requires to have, like similarly to test-driven development or documentation-driven development, a production-grade driven development. So that means that the processes are optimized for longevity and sustainability. So while you upstream, you're thinking about, I'm upstreaming, my main problem is not introducing any regression, not breaking things, and be compliant to the licenses of the upstream project where I work, be it a good gatekeeper, maintainer, peer review, and all that stuff. Now you had to start thinking about longevity, sustainability, cost of maintenance. And a big part of the cost of maintenance and cost of ownership in open source is related to licensing. So how much does it cost me to build a first bill of material? How much does it cost me if I don't identify the risks upfront? How much does it cost me, to maintain that bill of material current as I up rev packages, and then maybe the underlying licenses will change, right? And then you end up in potential conflicts between one license and the other. It means constrain cost of ownership and maintenance and minimize the technical debt. It means that that layer of technology that you start developing for your specific products, you have to make sure that it goes upstream as soon as possible, because otherwise your technical debt is increasing over time. You move from upstreaming to integration, packaging, and selection of component. You had to set up CI and CD to track upstream, tagging releases, and identify functional and system performance regression. And now you start hosting and managing releases, and then you start documenting. You need to track user experience. And then before you know, you have a continuous deployment system for lifecycle management, OTA and updates, and establishing a policy for current releases, end of life cycle, parallel releases, and so forth. So where are we taking compliance? So initially it was about training, being aware that it exists, friendly licenses, collaborative engineering, kumbaya, old singing, drinking off the Kool-Aid, fantastic, no problem. But as you move into production grade and more dedicated services, the infrastructure has to grow. You had to start hosting Git repositories for code and binaries, public and private branches. Consider multi-tenancy, SOCs as device makers, and code to audit toolchain. Set up a toolchain associated to CI and CD that start from coding and goes all the way to audit continuously. Fussology, OSScan, scan OSs, and then the IP auditor all connected into this code to audit toolchain. Generate continuously compliance artifacts, release notes, testing artifacts, low definition software bill of materials. Those are the ones that I define as automatically generated, and high definition software bill of materials. Those are the ones that are passed on to an auditor that takes that 30% done by Fussology and the other tools and identify risks ahead of time, unconformities, incompliances, talk with the engineering team to identify either a functional solution or just remove the offending component. But you understand that now IP auditing and compliance toolchain is part of somebody and a team that was just used to work upstream in a collaborative manner, and that drives a mindset change. And then you had to do that across the whole set of distros, AOSP, Yocto, Debian, and so forth. So this is where we are, and this is where we're going. Hopefully that kind of gives you a general idea in this lightning talk of the organization and how it's evolving over time. Questions?
Are there any questions? Yes? Wait.
I'm sorry, I came in a little late. Yeah, can you say what you mean by certification artifacts?
Yeah, so initially, I introduced Linaro as an organization that was created to do collaborative engineering in the ARM ecosystem with the main focus of upstream, right? And now over time, the organization is evolving toward serving a different population of users and customers, if you will, from SoC vendors to device makers, from upstream to product and services. As you build by taking from upstream the result of your work and package into an OS image, the device maker, the end customer, might have requirements when it comes to that specific device has to achieve this kind of certification. It can be an ISO certification, a safety and functional certification, a security certification. So all of those requirements make into the compliance tool chain, if you will, right? And then you test functionally from a performance standpoint that your OS image can comply with those certification artifacts. You had to generate those, whether it's in PDF, formal, whatever that is, and keep them current so that the device maker can take those certification artifacts to a certification authority to certify the final solution. Does that make sense?
Thanks. So I would suggest to close here. If you have other questions, then you're free to follow up. Thanks a lot.
Thank you.
Couple of minutes of break, and then last but not least speaker. Okay, so let's start our last speech of our legal track. Alexios Stavras from Intel, who is going to present the current state of SBOMs and SPDX.
Nice. Oh, I should be talking here. Hi. So, for those who don't know me, I'm Alexios Stavras. I'm in the OSPO of Intel, a large American company. But I'm here not to speak about what we're doing in Intel, but what we're doing for SBOM, what's happening in the world of SBOMs in general. SBOMs is software bill of materials, and SPDX is a standard format for representing that. We've heard before from Carlo and Alberto the need that you have to know what's inside your software. For example, to know all the license and all the license obligations that you have, or for security, or for any other reason. So the idea is to know exactly what's inside a piece of software. I have lots of slides with lots of information and not lots of time, so I'll be speaking very quickly and omitting most of what is in the slides. Slides will be uploaded, it's already uploaded, and you can view it on your own leisure at a slower pace. So what has happened during, let's say, the last year in the worlds of software bill of materials and SPDX? We start slowly to understand that when we're talking SBOM, nobody's talking about the same thing, right? So everybody's talking, yeah, whatever is inside your software. And this is not really clearly, defined what it is. Is it the components, the libraries that are inside the software I'm getting? Is it the dependencies that my software has? Is it when I install my software, what gets installed? When I deploy the software, what is inside the installer? What is in the final device after my software is installed? So we found out that during the wonderful software life cycle, at different points where you look at the software, what is the software bill of materials is a little different, right? So we realized that after years and years of talking about SBOMs, so we started defining different types of SBOMs, right? So there are SBOMs depending on when you're designing your software, or when you scan the source, you have the list of materials that are inside. So, for example, this one also has make files and stuff like that. When you finally reach an executable, these files do not exist anymore, right? And when you get a binary delivery, it's maybe a different image, right? So we should be starting thinking about, SBOM is not something that everybody understands, it's something very clear. And there have been now official definitions of different types of SBOMs, and depending on where you are, and the major idea is, I don't have it. So depending on where you are on your software life cycle, you can generate the corresponding SBOM, right? That was the main understanding that we got, that got propagated this last year. Now, SPDX is a community effort to define a standard in order to convey this information, right? We have to write it down in some format and give it to others. And so SPDX has a very long history. We started 2010 or something, and we're slowly, learning more and more and working more and more on that. In 2021, SPDX became an ISO standard. So if you follow official standards, this is what you should be following. After the official standard version, we already produced a new one, and now we are in the process of releasing the completely new SPDX version 3, which until now we were looking at SPDX version 2. We had to do some breaking changes, so we increased the major version number, as usually does. So SPDX version 3, why did you have to do it? It's, first of all, people are now thinking that when I'm getting information about software, it's not enough to know only the components that are inside, right? I want more information about them. Initially, I mean, 10 years ago, we were mostly looking about licensing. 5 years ago, we were introduced, let's have information about security. But now we're coming and thinking, you know, we're coming across new forms of software, right? AI, machine learning, whatever you want to call it. We have heard a lot of it today, right? So AI software is not only the components that are inside, right? It's also the data set, how it was trained, what's the weight, what's the model, right? Until now, we were not thinking about such things. Or provenance, right? How was this software actually built, right? And we heard from Carlo before that, you know, CRA says, you have to tell me about the provenance. Where did you get this and how was it there, right? How was it constructed, right? The other major driver for a new version of SPDX is we wanted to simplify, right? We started with SPDX version 2, and we started adding information, but it was essentially a monolithic framework. So now we broke it up completely into different pieces in what we call profiles, according to the area of interest. So we can have it, you know, a much more simplified version of that one. So we reorganized everything. And then we also added flexibility, right? Again, the use case 10 years ago was, I give you some software, so I have to tell you what's inside the bill of materials for this software that you're getting, right? Right now, you're not always getting a CD of software, right? You download, you get parts from here, parts from there, so you have to be much more flexible. You know, it's not a single unit of large software that you're getting. You have to be able to combine these things. So SPDX version 3 was developed in order to, you know, address all these things. And so we are building it. We create the specification completely in the open. We're using repositories on GitHub, and we write everything there. I mean, with issues and pull requests, as you would normally expect. And out of this, we generate automatically, you know, the specification itself as web pages or, you know, PDF that we want to publish. We generate ontologies, RDF, JSON, schemas, whatever you want, so that everything can be automatically checked and stuff like that. And the major change for people who were already familiar with SPDX version 2 is that we're moving away from a document model, which is a document describing everything, to element model, where there are individual elements describing pieces of software, and then you can combine them in an element collection, right? So again, it's the addressing the need to have it more flexible. And the main thing, as I said, is that we split things into profiles. And profiles, the word profile, we overload it in 3 different ways. It's the conformance. So when you get SBOM data, SPDX data, conforming to a specific profile, that means, yes, they have the information. If it conforms to licensing profile, they have the license information. But maybe you want to get data only about security and don't care about licensing. So we are allowed to split all this stuff. And we also use profile for namespacing and workgroups. So the people who are actually interested in working about security, they have their own meetings, they have their own, and they work independently, and they create the security profile, right? And these are examples of different profiles that we have. And I'll be running through them. So the core just defines the basic, what is an element, what is an object in an object-oriented language, right? And the relationship between them. And the software profile defines the very well-known, you know, what is a file, it's a package, it's a snippet, and, you know, all this stuff. Licensing profile all these are already known, from years now, right? How do I express license information? And we're still using, obviously, all the SPDX license list, all the well-known short identifiers for licenses, and license expression, so you can say this code is under GPL2 only or BSD3 clause, and people can understand what you're talking about, right? And yeah, we're having relationships between licenses and all this stuff. One major driving force is security, as you can imagine, you can probably guess, right? So we have now the ways to represent all the information that security people want to represent, not only vulnerabilities, but which one apply, which one do not apply, why do they not apply, even if they're patched or not patched, but this does not hold for us, and all this information. You can record all this stuff in security. Then we moved into completely new stuff like AI and data, right? So we have ways now to record information about, hey, this is a data set and it's under this license, and this is a provenance, and this is how I use it, and I use it to train my model, and this is the resulting model. All this information can now be recorded accurately. And this is until 3.0, and at 3.1, we started even working with that, but we will not be waiting for that for 3.0. Things like software as a service, safety profile, which is very crucial for embedded devices and for things that are safety critical. And we're also expanding into hardware, right? Because as you can imagine, software by itself, there are many cases where you have embedded software inside hardware, and you want to be able to describe the whole thing, right? Especially when you're talking about medical device, for example. So we have a way to describe, we will have a way, we're not there yet, to describe complete hardware and software. The nice thing about that is that hardware is already, more of a well-known problem, because hardware manufacturers have already been doing bill of materials, and they know what's happening inside their hardware much more than software build. So yeah, as I mentioned before, SPDX is completely open to anyone. You're free to participate. We have different teams that we're working. We are structured. There's the technical team, the legal team that reviews all the licenses and does all the legal stuff, right? And the outreach team, which I'm a chairperson, and we try to, inform people about that. And then we have, specific group, the profile group, the people who are interested in hardware, they go and meet there. The people who are interested in security, they have their own meetings, right? And all our work is done in the open online. There are mailing lists. We have meetings. Yeah, a few meetings. Usually where everything is happening on GitHub repos. Everything is transparent, and you're free to participate. And with almost 2 minutes to go, questions? Hopefully the replay in the video can be done in, 0.5 time, and you can do it slowly. Yeah. Sorry for speaking so fast.
Yeah. Question here?
Okay, thank you. Can you hear me? Yeah. Okay. I'm not familiar with this kind of tools, so I was curious to come and hear. But for a small project, I wonder two things. Which tool, if there is a command line tool to do this kind of job, to tracking all of this SPDX, and first, and then second, where do you get this information? For example, I'm a user of NPM. I'm just saying basic things. Yeah. Maybe you're laughing at it, but just I'm using NPM. So where do I get all of this information? Is it already in NPM I'm not aware of? So if you can comment about that. Thank you.
So I might be run a little more. Yeah. So tools. There are lots of tools. I did not talk about them. There are lots of tools that produce and consume this data, right? There is not a single universal tool covering all. because as you can imagine, a tool that handles NPM structure is much different than a tool that handles Java and has to know about Maven convention and stuff like that, or a tool that scans sources and finds license information inside source files. So there are lots of tools, and we have websites describing all of this stuff. Yeah, I can talk to you right afterwards about that. And where we get this information, again, there are a variety of origins. There is not a single central place where people can talk. Usually some package manager, for example, NPM has, for example, information about licensing, right? Or Debian, for example, every package has licensing information, right? This might be trusted or might not be, depending on what, how strict you want to be. And but this is license information, right? For security, you get it from security vulnerabilities websites and stuff like that, right? So there are tools that analyze your software maybe on the source, and they find your requirements, and they get you the list of everything, and then based on that, they go and query online information databases in order to get you the information.
I stop you, and maybe you can discuss this further. So I would like to thank all the speakers, and I will close now the legal track. Thanks a lot to everybody who participated in this very active discussion. Thanks a lot to everybody, and enjoy your free software conference.